Hello, everyone. My name is Joanna Watkins, and I have the honor and privilege of serving as your Florida Realtors Vice President of Law and Policy and General Counsel. Wow, what an amazing first half of 2022 we have had. It has been a very interesting year from a law and policy perspective. More law than policy, not a lot happening at NAR in terms of policy changes, but certainly Florida is never, ever dull when it comes to the legal landscape. I am so honored to lead an amazing team of attorneys, many of whom you have had the privilege of speaking to on our very, very popular Florida Realtors Legal Hotline. Y'all, for the first 6 months of the year, more than 42,000 phone calls into the hotline. So coming up with topics for today's presentation, not a problem at all. We are going to talk to you today about some of those topics that we were able to gather from information from all of you as you called in and told us in real time what is happening in the Florida real estate market. So we have a lot to cover, so I'm not going to talk too much, but I will tell you that coming before you today, I have my amazing senior team. First up, we are going to hear from our newest addition on the senior team, a gentleman that you heard from last year, Mr. Rich Swank. He has some amazing topics to talk to you about today. After Rich, you will hear from Marcia Tabak, our Deputy General Counsel, Meredith Caruso, our Associate General Counsel, Joel Maxson, our amazing Associate General Counsel, not all necessarily in that order, but you'll hear from all of them, and then I'll round it up with some information for you today. So without further ado, I turn it over to Rich Swank. Rich, the floor is yours.
Thank you so much, Joanna. Hi, my name is Rich Swank, and as Joanna said, I am an Associate General Counsel here at Florida Realtors. Today, I'm going to talk to you guys about a topic that has been kind of simmering for the last 2 years, but has just kind of bubbled over and blown over in the last 6 months. I'm going to go ahead and share my screen with you now, and I'm going to be speaking about local rental restrictions. Now, what do I mean by that? Well, the Florida statutes in Chapter 83, the section part of it is the Florida Residential Landlord and Tenant Act. That is the law that applies to all landlords and tenants, all rental structures in the state of Florida across the board. However, each local jurisdiction, such as a municipality or a county or a city or a town, has the ability to pass their own rental restrictions. And those are what I'm going to talk about today. Now, the ones that we are seeing bubble up in the last 6 months usually take 3 forms that I'll get to in just a minute. But just to give you a quick refresher on Chapter 83, Section 83.57 talks about the notice required to terminate a tenancy without a definite term. In other words, no written lease. This can be month to month, week to week, quarter to quarter, or year to year. Just for examples, 83.57 says you have to give at least 15 days before the end of the monthly period in which rent is due in order to terminate a month-to-month tenancy. Section 83.575, this statute allows the parties to add a notice to provision to the lease, to a lease, for renewal or non-renewal, but it is not required. It can be up to 60 days, but it is not required. You'll notice that there is no notice in Part 2 of Chapter 83 that requires a notice to increase the rent. Also, there are no statewide rent controls. As I said before, counties and municipalities are now increasingly passing ordinances or going to rezoning to restrict rentals. Local rental restrictions usually take one of 3 forms. The first, which is the most prevalent right now, is a tenant's bill of rights or a notice for termination or for rent increase. We first saw this in Miami-Dade and Broward counties, and it is now spread to multiple other counties. The way this goes is that as is that they may be required to give some sort of notice or some sort of paper to the tenant. The second form are short-term or vacation rental restrictions. This is when the municipality or county tries to limit the way in which homeowners can rent their properties out in a short-term or vacation context. And then the third form, which is the most recent, is rent control or stabilization. The county or the town actually tries to limit how much landlords can increase their rent. Now, I have to caution as we get into this, this is only an overview. Let's pretend we're sitting in a plane 30,000 feet above the ground, and what we're going to be talking about are on those little islands you see there over the left wing of the plane. The reason we can only do an overview, as I will get to later on in the presentation, is that these things can take many forms and can take forms for counties or cities, even within counties within the state, or cities and municipalities even within the counties. And not all of them are uniform. Not all of them are the same. So like I said, the first type of restriction you can usually see is a tenant's bill of rights and or increased notice. This may require the landlord to provide a copy of a bill of rights or a similar document to the tenant. The bill of rights or document usually tells the tenant what their rights are under the state law and any local laws that have been passed. In other words, the amount of notice they're supposed to get, or when their leases are going to be terminated or something like that. Now, the ordinance may increase notice provisions for termination of month-to-month tenancies or increases in rent even without a bill of rights. Miami-Dade County passed one of these things before their Bill of Rights was ready to go. So the ordinance itself may contain different things that are in an actual Bill of Rights, or a Bill of Rights may not exist. The ordinance may also create protected classes in addition to those under the federal or Florida Fair Housing Acts. We've seen this in Miami-Dade and Broward counties. It has also been introduced in other counties, such as source of income. In other words, you cannot discriminate against a tenant just because they are receiving Section 8 benefits, for example. Here's an example of Miami-Dade's Notice of Tenant Rights. And as you will see, this is only page 1 of 6, but it does have 2 of the different things that I talked about. The first thing, which you can see by the arrow, is the landlord's responsibility. Landlord is required to provide you with this notice, which has been prepared and published by the Office of Housing Advocacy no later than 10 days after the commencement or renewal of your tenancy. In other words, Miami-Dade County requires landlords now to provide this document to potential tenants. Also, it contains the new notice provisions. As you can see, month-to-month termination of tenancy. Your landlord must provide you with a minimum of 60 days fair notice in writing of termination of month-to-month tenancy, i.e. you do not have a written lease. So in other words, this document has to be presented even if a lease doesn't exist. Furthermore, your landlord must provide a minimum of 60 days fair notice in writing if your landlord intends to increase your rent by more than 5%, either at the end of a lease or for a specific term or during a tenancy without specific duration. Like I say, this document gives the tenant an idea of what to expect, but this is not going to be uniform from county to county or city to city. Each one may have their own different thing, and they may have something different as to a tenant's Bill of Rights or an ordinance. Now, the second form that the local rental restrictions we've recently been seeing are taking are short-term or vacation rental restrictions. In other words, usually trying to stop the use of condominiums or single-family homes for short-term vacation rentals, VRBO, Airbnb, etc. They may be implemented by an ordinance or, as we are seeing, by changing the zoning of the property from residential or to residential, commercial, residential. We're seeing different forms. In other words, if you own a property within this particular zoning area, you may not be able to rent your property out on a short-term basis. The statute or the ordinance may also require a landlord to register short-term rental properties. In other words, registering them with the local county and then abiding by certain rules or restrictions having to do with rentals. They may restrict the use of properties for short-term rentals in addition to vacation rentals, such as seasonal rentals. Also, and this is even worse, they can be implemented by condo or homeowners associations in their governing documents and bylaws. So you could see a rental restriction in an ordinance and in a condo or homeowners association document. Let's take a look at one of the examples. This is Collier County's ordinance. It was passed in December of 2021. As you can see, it doesn't rezone and doesn't really restrict the use of property for short-term rentals, but it does require the landlord owner to register the property with the county, maintain all short-term vacation rental units under the control in compliance with occupancy limits, and be available in person or by telephone, or have the designated person or responsible party available by person by telephone for 24 hours a day, 7 days a week. In other words, if the county gets a noise complaint or the county gets some other sort of complaint, the owner has to make themselves available or have a property manager available to respond to the county's inquiries. Now, the third type of rental restriction we have seen is rent control or stabilization. In other words, counties and cities are now endeavoring to actually prevent landlords from how much they can increase rent in an annual period. Now, this is a very high bar that the municipality or the county must clear. It's heavily restricted by either section 125.0103 and or 166.043. Both were passed in the late 70s. They can only be used to eliminate an existing housing emergency, which is so grave as to constitute a serious menace to the general public. Now, that's not defined in the statute, but it sounds pretty bad. They can only be implemented by public referendum. The county can't pass them on their own. They have to put it to a vote of the county, of the people that live in the county. This year, there has been a great deal of pressure to try to put them on the ballot in the fall, or some were even trying to get them on the primary ballot here at the end of August, although most of those appear to have failed. The statute or the ordinance can last only 1 year unless it's put on the ballot again and then reestablished once again by referendum. So as you can see, it's difficult for a county or a city to establish something like this because it has to be a really bad situation. It has to be voted on by the voters, and it can only last 1 year. Here's an example of one of them that was recently, the Orange County Commission recently voted to put on the ballot in November. This is the July 29th, 2022 draft, which is fairly close to what they eventually voted on. As you can see on the left, no landlord shall demand, charge, or accept from a tenant a rent increase of a residential rental unit more than once in a 12-month period. In other words, the landlord can't enter into several leases and then increase the rent at the end of each lease. They can only increase it once. No landlord shall demand, charge, or accept from a tenant a rent increase that is in excess of the consumer price index of the existing rent for any residential unit except as otherwise allowed under section 25.3-388 of this ordinance. In other words, those are exceptions having to do with landlords that have to do significant repairs to their unit. However, you can see that this endeavors to limit all rent increases only to the consumer price index. In other words, which I believe at this point is around 7%. Now you can see also that under the statutes that I talked about earlier and other statutes within the Florida statutes, that there are a number of exemptions that apply to these things. That this does not apply to rental units. This does not apply to units offered for residential purposes as a second home. This does not apply to units located in a single family home, townhome, condominium, or mobile home. It only applies to apartments. It does not apply to rental units that a governmental agency or authority owns, or dwelling units located in a cooperative apartment occupied by a holder of a proprietary lease. I skipped letter C there because that's one that is still very much up in the air. When this statute was passed in 1997, it did not apply to luxury apartments, which at the time was any apartment that had a rent of more than $250. Still hashing out what that really means. Now, these are just a few examples of the various different types of restrictions that have been passed across the county, across the state. Like I say, they are spreading rapidly, and they are different in every single place that they are passed. As you can see, Miami-Dade and Broward, they followed each other's lead pretty much with the Tenants Bill of Rights and the notice provisions. Pinellas County decided to impose a 60-day notice of rent increase, but did not impose an increase on notice for month-to-month terminations. Orange County has passed a Tenants Bill of Rights, and like I said, recently passed rent stabilization. The Village of Royal Palm Beach passed notice of rent increase or termination. Not Palm Beach County, the Village of Royal Palm Beach. As we saw before, Collier County has a vacation rental registration provision. City of Tampa imposed not Hillsborough County, City of Tampa imposed a 30-day notice for termination and a 60-day notice for rent increase, but recently defeated an ordinance that would have restricted rent increases. Now, Florida has 67 counties and at least 953 cities. As I said at the beginning of this presentation, this is only an overview. The Florida Realtors legal hotline, because this is spreading so rapidly and because these are so different, cannot stay current on all of the local changes. That is going to be the responsibility of each buyer, landlord, or property manager in the particular county or municipality. So what are our takeaways? These laws are spreading very rapidly. They're passing virtually every week or every other week, every month in various different counties across the state. These restrictions can be imposed by just about anybody, a county, a city, a town, a condo association, or even an HOA. So what is the major takeaway? If you are a property manager or you represent an investor buyer, bring the spread of these restrictions to your customers' attention so they or their attorneys can do research and due diligence. Avoid interpreting these restrictions for your customer yourself, because they are diverse and they change quickly. And as I saw, they can be very, very different. That's my presentation for today. So now I'm going to hand it off to Meredith Caruso.
Hi, everybody. Okay, so I'm going to talk to you. My name is Meredith Caruso. As Rich said, I'm Associate General Counsel at Florida Realtors. I'm going to talk to you about something I hope that you have heard about. So let me share my screen with you. So hopefully everyone has heard of the new condo law. So what I'm going to do is just kind of go over what this is and talk to you about what forms that Florida Realtors is likely going to have to change as a result of this change in the law. Little background. Senate Bill 4D passed during a special session that took place at the end of 2022. It was designed to increase building safety, obviously as a result of the Surfside collapse. We do anticipate there might be some changes in the upcoming session, some clarifications, tweaks on the language. I got a couple of examples of what that I might mean by that. Again, this is going to be a general overview of the law. I do not do a very deep dive into this. There's a lot in there, but these are the main takeaways for this. Okay, so the condo law creates a statewide milestone inspection requirement for condos and cooperative buildings that are 3 or more stories by December 31st of the year in which the building reaches 30 years after the initial occupancy, or 25 years after the initial occupancy if those buildings are within 3 miles of the coast. Then those are required, those inspections every 10 years thereafter. If a milestone inspection is required and the building certificate of occupancy was on or before July 1st, 1992, then that milestone inspection must be performed before December 31st of the year 2024. It also creates an obligation of condo and cooperative associations to perform what is called, we're referring to as the SIRS, a Structural Integrity Reserve Study. And that has to be maintained for at least 15 years after the study is completed. Structural integrity reserve study is defined in the law as a study of the reserve funds required for future major repairs and replacement of the common areas based on a visual inspection of the common areas. And the statute lays out specifics that must be included in that SIRS report. Both the milestone inspection report and the structural integrity reserve studies have been added to Condo and Cooperative list of official records. These are open to inspection by any association member or an authorized representative, as well as renters. Effective December 31st, 2024, the members of a unit owner controlled association may not determine to provide no reserves or less reserves than required for the items to be included in the SIRS report. All right. So what happens in terms of enforcement? All right. So the Division of Florida Condominiums, Timeshares, and Mobile Homes may enforce and ensure compliance with complaints related to the procedural completion of the milestone inspection and the SIRS. If an association fails to complete a structural integrity reserve study pursuant to the new law, this failure is going to be now a breach of the officer director's fiduciary relationship to the owner. So the non-developer disclosure list of items buyers entitled to at a seller's expense has now changed to obviously include these milestone inspection report summary and the association's most recent SIRS, or a statement that the association has not completed that SIRS yet, okay? We're working on incorporating this into the existing affected forms. However, something to note, the mandatory contract language was not changed with this law, and I'm going to get into that more in a second. All right, so what forms are we looking at possibly changing as a result of this? We have a seller's property disclosure specific for condominiums. Obviously, that will need to be updated. There's sections on structures, water intrusion, that is more than likely going to need to be revised. I would imagine something like, is the building 3 stories or more? Would be a great question. Is the law even applicable to the subject property? Our contract for residential sale and purchase, the CRISP addendum for condo associations, will also likely be revised. However, it's important to note as of right now that disclosure portion of the addendum wasn't changed by the new law. So what do I mean by that? You are more than likely familiar with this screenshot right here, okay? This is the little boxes you're checking both on either the CRISP rider or CRISP addendum or the FAR rider with regard to condominiums. This is where it says either the buyer's checking that they've received certain condo documents or they haven't received them in the second box, okay? And they have that 3-day right of cancellation once they do actually receive them. So this particular section, this all caps language, this is directly from the current law that says, hey, this has got to be in your sales contract, all right? What I meant earlier is that actually this section, which lists out, gives you a list of everything that the buyer is supposed to receive at the seller's expense, that wasn't updated to include the milestone inspection as well as the SIRS. So hopefully that will be addressed in the upcoming session, and so that we can change this section. Otherwise, we might be looking at adding some sort of separate section in relation to that. So again, the new law did not change this section of the statute. So while those milestone inspection and the SIRS are listed as official documents of the association, all right, the language, the statutory language, which I just showed you on the previous screen, was not changed, okay? So it wasn't updated to reflect the change. So hopefully, like I said, this will be addressed. This is the exact same with the addendum that we have available for the contract and sale and purchase of a cooperative. There is statutory language under that section as well. That was also not changed. But again, the buyer is still entitled to those milestone inspection summaries, if applicable, and the SIRS statement or a statement that the SIRS hasn't been completed. Also, we will be looking at the receipt of condo and co-op documents form. That's the one where the buyer is acknowledging, signing off that they've actually received them, so that we can reflect an accurate list of what the buyer is entitled to. What we're looking from you guys is if you have any other forms that you can think of that might need to be updated because as a result of this new condo law, please submit them to forms@floridarealtors.org. And would be awesome for you to submit anything else that you can possibly think of. We are going through a lot of these. I appreciate your time, and now I'm going to pass it over to Marcia Tabak, and she's going to speak to you on her topic.
Hi, everyone. It's Marcia Tabak, Deputy Legal Counsel at Florida Realtors. Okay, we've done it. That was the most difficult part of this presentation. Okay, so I want to start out by talking to you all about a subject that I've been worried about. So let me start by asking a question. How many of you create or use floor plans as part of your marketing strategy? If you do not pass go, do not collect $200. And hopefully you all recognize that phrase from when we were kids and we used to play Monopoly all the time. That's because I want to talk to you about an important case. The case is named Design Works Homes, Inc. versus Columbia House of Brokers Realty. This may be somewhat familiar to you because this case was actually filed in 2018, a number of years ago. And it may be familiar to you because NAR has been following the case. I want to do a little bit of a drill down. So we're going to start at the beginning. So here are the facts. There were two different brokerage companies that took two completely different listings on two completely different homes, and the listings were taken by two completely different listing agents, okay? What the two listings had in common was this. Both of the homes were constructed by the same builder, okay? And they both had a somewhat unique triangular atrium design with stairs, okay? One of the homes was built approximately 20 years prior to the lawsuit, and the other maybe 15 years prior to the lawsuit, okay? Independent of each other, the listing agents in both situations created a floor plan of the home. And I'm somewhat thinking it may have had to do with the triangular atrium design with stairs. One of the agents actually went to the home, measured the property, and sketched out a floor plan on a piece of graph paper. The other agent hired a contractor to create the floor plan through a computer design. Nonetheless, after both agents started marketing the properties and the floor plans were distributed, the builder of these homes went out and copyrighted his original design. Following this, the builder and construction company filed suit against the brokerages and the listing agents, alleging that the floor plans they had created infringed upon the builder's copyrighted plan of the home. This actually occurred in Missouri, and the trial court had a motion for summary judgment where the defendants, the brokers and the agents argued that their creation of a copyright was not a violation. Their creation of the floor plan was not a violation of the copyright because of a copyright statute, and that was 17 U.S. Code Section 120A. That section provides a copyright in an architectural work does not preclude others from making pictures, paintings, photographs, or other pictorial representations of the work, so long as the building is visible from a public space. So they actually convinced the trial court that the floor plan was akin to a picture of this copyrighted work, and the court dismissed the action. And this was, of course, wonderful news to the brokers, but the builders were dissatisfied and filed an appeal. This appeal went to the 8th Circuit, and the 8th Circuit then went about analyzing 17 U.S. Code Section 120A itself. And the way the 8th Circuit looked at the section, it determined that what the section permitted, which were paintings, pictures, and photographs, of a copyrighted work that had been built, the court found that that allowed for artistic expression. Then the court went on to specifically find that floor plans were not pictures and they were not pictorial representations, which were permitted under Section 120A. Instead, the court found that floor plans were technical drawings and served a function. The court went on to specify that had Congress wanted to protect floor plans within Section 120A, Congress would have said so. In addition, the Eighth Circuit in its analysis focused a bit upon the Section 120A that specifies that pictures are permitted of copyrighted works if the building has been constructed as long as the building is visible from a public space. Here the court postured that it was very unlikely that a floor plan could have been created by viewing the building from the outside. So what we had was the Eighth Circuit determining that the trial court had been wrong. The Eighth Circuit reversed the trial court's decision and in essence sent the case back to the trial court. What concerned the real estate community was this. This ruling determining that Section 120A did not include floor plans called into question the lawfulness of creating floor plans for a building built from copyrighted plans. So the real estate brokerage company and the agents actually filed a petition for certiorari asking the United States Supreme Court to weigh in on whether floor plans are exempted from copyright infringement under Section 120A. Now, we got the ruling from the U.S. Supreme Court on June 27th, that the United States Supreme Court would not hear the petition. Okay, so the petition was denied. So where does that leave us? We go back to what the Eighth Circuit did, which was make a determination that this needs to go back to the trial court. Specifically, the Eighth Circuit did leave the door open for the defendants to argue that their use of a floor plan was a fair use and should be exempt under the fair use exemption. What the fair use exemption allows the court to consider is the nature and the purpose of the use of the infringer. So here we've got the brokerage companies using this for a commercial purpose. Okay, so that's one thing the court's going to look at. The court is also going to look at the nature of the copyrighted work. They're going to look at how much of the floor plan actually utilized the copyrighted work and the effect of the value on the copyrighted work. This, the difficulty is here that the fair use exception is determined on a case-by-case basis. So it's very difficult to rely on it without having the court hear all the details. So we want you to be aware that the Copyright Act has a 3-year statute of limitations. Usually the statute runs from the date the owner of the copyright learns of the infringement. We also want you to be aware that it is not a defense that the defendant who created or used the floor plan was not aware that the work was copyrighted, okay? Once the infringement is proven, the statute authorizes attorney's fees. It also authorizes actual damages and any additional profits of the infringer, or the copyright owner can seek statutory damages, which can range from $750 up to $30,000 per infringement, and all the way up to actually $150,000 if the infringement is found willful. So this has some take-home lessons. We want you to go back to your offices. We want you to talk about this. We want you all to figure out, is anyone in your office creating floor plans for marketing purposes? If the answer is yes, we are asking that you make a risk analysis as to whether it really is valuable, and we want you to make a decision as to whether you want to risk possibly being sued by the owner of a copyright set of plans. Now, if you are using the floor plans on a new build, we are suggesting that you obtain the consent of the builder if he owns the copyright. If he doesn't, you need to obtain the consent of the architect who created the plans. And we're asking you to stay tuned because we will let you know what the outcome of this case is. Interestingly, apparently this is the first case where this section 120A of 17 U.S. Code has been interpreted in the way that the Eighth Circuit interpreted it, okay? So now, remember at the beginning I used my monopoly analogy. So I think now that we've gone through this and now that you're aware of the situation, I'm happy to say you are ready to advance to go and to collect your $200. And that again is a nod to those of you who play Monopoly now or you did when you were a youngster. So I am done with my portion of the program and I am going to kick it back off to Joel Maxson to talk about some other matters.
Thank you so much, Marcia. And although I have played Monopoly, I can't say that I've ever finished an actual game. It usually ends in a fist fight or at least the board getting tossed. So my name is Joel Maxson. I'm also an associate general counsel. And the main job that I do at Florida Realtors is to manage the legal hotline. So you may notice throughout that I continually kind of look at things. Even this whole presentation is really just a compilation of a number of different calls that I've kind of squished down in something. I always like to try and make it as practical as I can. And it really is just looking at these topics through the lens of the legal hotline. I'm going to talk to you today about what I'm calling DIY, do-it-yourself legal clauses. The main thesis, which you're going to get, is really just a simple takeaway. I just want to make sure you can see legal language as we do. Because a constant conversation is people say, we've got this clause, and they kind of expect that it's simple or we can explain it. And I go, it's drafting. Drafting is far more challenging than most realize. So when it comes to language in a contract, well, what in a contract itself or one clause within a contract, where can somebody get language? Well, obviously, they can always hire a lawyer. So if they just want a modification or whatever, feel free at any point to get your drafting from an attorney. Second option that parties have is to find some attorney drafted language like a form. Obviously, you're very familiar with the forms. As our realtor members, this has been prepared by and is designed to be predictable and precise. So form language is a second option. And then the third option is to do your own DIY legal clause. So what do I mean when I say DIY, do it yourself? Well, it's something like this. It's something that gets added, usually in additional terms in the contract or in a blank addendum. Landlord and tenants will sometimes find a way to squeeze it in a lease as well. It's typically very, very, very often just a brief phrase or sentence, and it's an attempt to modify the existing contract or even add a new term. Here are three examples. One example of a clause that we hear about a lot on the phones. The inspection period shall expire on blank. Put in a new deadline. Pretty simple, straightforward, but that's one type of clause we hear. Second clause that people do themselves, seller to repair list of items noted on inspection report before closing. And the third clause, contract not contingent on appraisal. These are all things that everybody here has heard more than once members call about. And let me break this down in an analogy. I said DIY, I'm borrowing this from a home improvement world. So, when it comes to DIY stuff, some issues are easy to complete. Let's just say I had found it a challenge to replace a toilet seat. So putting knobs on a thing, getting fancy decorative knobs and adding them, I actually managed to do that. That's easy to complete. Some DIY tasks are challenging but doable, like replacing a tile floor. Mine would probably be an absolute disaster, but some people can manage to do it, watching YouTube videos, just figure it out. And the third, some are so complex and require such massive construction or change of substantive things and load-bearing walls that if you try to do it, it's likely to be a mess. And then it's also likely you're going to have to go hire a professional and pay them more than you would have paid if you'd started with them to fix it in the first place. And by the way, if you're paying very close attention, you may notice that those three categories kind of line up with these clauses. Very few people screw up the first one. So when we talk about it, we're usually just talking about dates. Every now and then there's a little wrinkle here and there. Did you forget about this other date, or it was a little clumsy, but that's pretty easy. Most people can do that. That's like putting a knob in. Number two, list of items. Ooh, if it's a simple fix, if buyer and seller are on the same page, if it's something that's pretty easy to do, people don't fight about this very often. It doesn't fall apart. But I warn you, if you compare that sentence to our inspection repair contract, you're missing at least a page of words that the attorneys thought were necessary. But, it's middle of the road. It's replace and top. And the third one, contract not contingent on appraisal. I get what people are trying to do. They're trying to modify the financing contingency, the buyer's escape hatch, but it doesn't even reference the financing contingency. Many, many, many times when people call about that clause, there isn't an appraisal contingency. So we kind of go, yeah, not contingent on appraisal. There's no appraisal contingency. There's a financing contingency. That's different. So that third one is much more hard and much more complex and hard than most people realize. To further break down, okay, so let's say someone does go with the DIY clause. What are the main issues we hear about? It really boils down to lack of clarity. Unclear language can lead to a dispute. And when there's a dispute, the problem with these short clauses is it can be an uncertain outcome. And by the way, there are many different types of unclear language. A common one we kick around in the legal world is ambiguity. That's stuff that's open to more than one interpretation. You might be wondering, looking at the left, why is there a picture of a rabbit there? Well, the answer is because it's an example of ambiguity. If you're looking to of a right-facing rabbit with its ears coming off to the left, you may see that. Or you might see a duck with the left-facing face, and that's the bill of the duck, and that's the eye. So in both cases, it's the eye, but look to the left, it's a duck. Look to the right, it's a rabbit. It's both. And there's room for both to be true in that picture. And that's exactly how it works with language when it's sort of open to two interpretations. I go, ooh, that's a jump ball. Vagueness is also very, very, very common when there's just not enough detail. It's kind of like that photo at the bottom right, a lovely picture of, I have no idea what that is. That's also open to interpretation. I'm guessing that's a field with trees on the left, but I don't know. It's a very vague picture. And then there's also can be mistakes and conflicts. And why am I kind of harping on these DIY clauses and saying if they lack language, you really got an issue? Because this is how courts look at words. They don't cavalierly say, we'll figure out what you meant. We'll get to the bottom. No, when you hear courts talk about language, they will go to levels of detail that to us, we go, yeah, this court's doing what they do. But to someone who's not familiar with the court process might scratch their head and go, what the heck is this about? This is an actual case where a judge was trying to determine what the word and meant. And the judge, I'll just read the first part. Professor Dickinson is not the only scholar to assert that the several meaning of and is commonplace. Indeed, Professor Brian A. Garner agreed in his Dictionary of Legal Usage. The meaning of and is usually, but not always, several. Moreover, at least one court has agreed that when the word and is used in a permissive sentence, it's likely to be used in its several sense. So you kind of look at that and go, okay, wow, you're really, really just going pretty far into the word and. Surely that settles the issue. Not so fast. This came from a drafter that I love. I read this guy. I mean, he's one of my I'm a fan. and this person writes a blog post about legal drafting and precision. And he wrote about that court opinion I suggest that doesn't make sense. And then at the end, that second bullet point is really kind of an important takeaway. So if you think courts will figure out what something means, this is from someone who is an insider's insider who says the awkward reality is that judges are dilettantes when it comes to this kind of ambiguity. That's because it's gruesomely subtle, the stuff of linguistics. So when you're looking at a DIY clause, beware that you're leaving it up to a court who, even in the best of circumstances, it might be unpredictable. So here's another example. This one would drill down just a little more careful to contrast it with a different type of example. I know that as of the recording of this and as of the convention, these are less popular than they were a couple of months ago, but for at least a year, these were wildly popular and we would hear all sorts of calls and conversations about them. And this is sort of a popular phrasing that we would hear about. Buyer agrees to pay $10,000 over appraised value not to exceed the purchase price. And I get it. I get what people were trying to do. They were trying to sort of address if the appraisal comes in low. Typically when there's a lender, buyers agreeing to throw out extra money ahead of time, and that's the gist. But when you put this under a microscope as finely tuned as the judge trying to determine whether and means one thing or another, whose appraisal is this? Exactly. And by the way, if you're thinking, well, you can just ask the buyer and seller, that's not how it works. Judges are loath to do that. They like to look in the four corner, only look at the words on the page and figure it out from there. That's the sort of default setting of courts. So these are important questions. Whose appraisal? Sometimes people are typically assuming we're talking about the lender's appraisal, but what if the buyer says, I don't agree with that. I'm going to get my own appraisal, and that comes in at a very different number. Which one counts? What if the seller says, I don't like that, and they get their own? Does that count? What about some fourth option? There is no right answer because there's not enough words. Is the seller obligated to reduce the purchase price if the appraisal plus 10,000 is well under? This is a conversation we had many, many times. I mean, it was sometimes 6 figures under what they thought it would be. And they go, whoa, that's way lower. I don't have to drop the purchase price that low, do I? And my answer is, I don't know. It's not abundantly clear here whether the purchase price gets reduced or not. You can say it's implied, but that's an argument. Again, we're back to the duck rabbit. We're back to the fuzzy picture. I don't know where this is going to go. And then the last one that was a common one. Let's say the lender nonetheless denies and says, forget it. We're not approving. Can the buyer still cancel penalty free due to the financing contingency? Or are they locked into this because of this clause? I don't know. It's not clear. It doesn't even mention the financing contingency. And last, what precisely is an appraisal? Could it be a CMA, or does it have to be Florida? It's not clear. So lack of clarity tends to be the problem. And that's just an example of it. And if you contrast this with some appraisal language that our Florida Realtors, Florida Bar committee has put together, it's much more easy to see the clarity, to see the picture. So in this appraisal contingency, and I get these do 2 different things. We actually have one that's not quite ready for publication. Otherwise, I would have used that. It's actually an appraisal gap clause. But I'm going to use this because this is published as of the day. It's an appraisal contingency, fairly short, but you can see it's a lot more words than what we just saw. Whose appraisal are we talking about? The buyer. That's it, the buyers. So we know exactly whose appraisal it is. And what if the appraisal is lower? Well, we know the buyer can cancel. It says it right there. The buyer has the option to cancel if they want or not. And when can they cancel? Well, there's a very specific 3-day window that's laid out there. You could look at a calendar and say, there it is, these 3 days. And where does the appraisal come from? What are we talking about? It must come from a licensed Florida appraiser. All right. So a lot more detail, a lot more chance to answer these questions, and a lot more clarity. So before I leave you, I'll try and make some practical takeaways here. Because at the end of the day, it truly is up to the parties what they want. Remember my shopping decision from the first, they could hire a lawyer if they want. They don't have to. They could try and find form language wherever they can find it. You know, in our resources, there are abundant resources that cover a lot of areas. And even if not, there are other forms out there that they might find. The third option is these DIY clauses. So that's always their decision. I guess that is I will fold that into the takeaways and then say also kind of the point of this. A lot of people seem to think it's easy. It's not. Top-notch quality legal drafting is very challenging, even for attorneys. If I told you the amount of time that we spend kicking around languages they draft, it's a lot. It's many, many, many hours. If I told you these forms committees, how they discuss and deliberate, it takes a lot of time. It's very challenging. Second, parties should consider what future landscape might look like if they disagree. You know, when I kind of compared those 3 options for where they want to get one, well, they might want to consider this. Are we talking about an inexpensive issue, a simple, or one where the person on their side is very cooperative and friendly? Maybe that might lend them towards a DIY works in the circumstances. If it's an expensive issue like these appraisal gap clauses were, tens of thousands of dollars in many cases, if it's complex, and if the other side happens to be litigious or angry or hard to work with, factor those in. You know, those are things that I really wish more people would factor in before they just kind of went with their own clause. Consider the landscape. And then last, we tend to say they should engage lawyers more often than they do. That's just sort of our bent. It would save people a lot of time, energy, headaches, and a lot of times it's just appropriate and helpful. And the last couple of members should be extremely cautious. I've kind of avoided or sidestepped the question of how much should you draft or can you draft. I'm not really getting into that here. I'm just pointing out in general these clauses we hear about on the hotline. But I'd say for your sake, be extremely cautious about assisting And we can always talk about that in more detail later. And then finally, although parties are welcome to do their own DIY drafting, the outcome of disputes over them can be very certain. That's probably the main conversation. They say, surely there's an answer. Most of the time, the answer is, I don't know. So thank you for your time today or tonight, wherever you're viewing this. I'm going to send this over to our esteemed General Counsel, Vice President of Law and Policy. It is a pleasure working with her day in and day out, Joanna Watkins.
Thank you all so much. And listen, I think we all can agree that was some amazing information that my team shared with you today. And I want to thank Joel for that last presentation. It was one that I actually wanted to give, and he was kind enough to give it for me. And let me just tell you, and I want to speak to the brokers in the room in particular. I'm gonna give you a fresh update now. And one of the things that we know is that on any given month, we add 2,300 new agents to this business. And I'll get to the detail in just a moment. But we had a case where we listened to oral arguments. And if I'd had my way, I probably would have spent 30 minutes of this hour showing you the YouTube video from those oral arguments. My team talked me down. Well, I wanted to because I was mortified that the judges spent probably the first 10 minutes of the oral argument talking about punctuation on one of our Florida Realtors forms. And so it worried me because, particularly for our new members, I hear clauses all the time where there is no punctuation. They're great words on the page, but like we sometimes are drafting for buyers, sellers, to get the deal to closing. When the FAR committee, when they're drafting, when the forms committee, when they're drafting, we have a completely different mindset. We are trying to draft language, as Joel said, that is going to withstand the scrutiny of the legal system, including punctuation, right? And so as I get ready to share with you my annual PREC update, I want you to think about the fact that there are a lot of new agents out that really need to hear this information. So let's talk a little bit about what's happening with the Florida Real Estate Commission. I love the fact that we have so many people come out to convention and so many realtor events, but really it all starts and stops with your license. So let's talk about licensing. The Florida Real Estate Commission is in unprecedented territory. As of the end of their fiscal year, which is June of 2022, they have a total of 462,036 licenses in all categories. And that is the highest number of licenses they have ever had. And it is certainly the largest real estate program in the state. The application numbers remain very, very strong. As you can see, for May of 2022, 5,300 applications, not much change in June of 2022. The numbers remain strong at 5,323 applications. Now, slightly less than June of 2021, when there were 5,464 applications for broker and sales associates. So the numbers are slightly less, but not by much. So the folks coming into the industry remain strong. And we know from the application numbers and the exam numbers that there are approximately 2,300 sales associates on average coming in every month. So all of the issues that we've talked about today, areas of risk, areas of exposure, all of the things we've talked about in recent years, you have to continue to emphasize those within your office because there are so many new people within the industry. Enforcement. So the Real Estate Commission continues to have a very strong enforcement program. You can see from the blue line on the top that the complaint numbers continue to remain very, very strong. In May of 2022, up to 628 complaints received that month. That was the largest number that they have had in recent years, in some instances double what they had received historically. Down slightly in June of 22, but overall, you can see that transactions in the state, as they increase, so do complaint numbers. So a direct relationship between real estate transaction numbers and complaint numbers in the state. Unlicensed activity still remains a priority for the Florida Real Estate Commission. And so you see here that in June of 2022, they received 50 complaints for unlicensed activity. So those numbers seem to be on the rise. I would say that if you are out there, you are a hardworking realtor, you have done it all correctly, you have taken the pre-licensing education, the exam, the continuing education necessary to maintain your license, and folks are out there not doing it the right way, file the complaint with the Real Estate Commission. They are obviously seeing an increase in those complaints, and they are happy to take a look at those. So those numbers remain high. They continue to have an audit and inspection program, although those numbers are down from where they have been historically. The numbers for 2022, not as strong as 2021. I'm not sure to what to attribute the decline, but in 2021, they conducted 908 inspections and 246 audits. And then so far, first half of 2022, only 107 inspections and 51 audits. So, we've definitely seen a decrease there. Not sure what they have planned for the second half of 2022, but hopefully they'll get back on track with their audits and inspections. Now, I want to put a couple of very important issues on your radar when it comes to the Florida Real Estate Commission. It is our absolute pleasure to attend those meetings on your behalf every single month. Now, I will say you too can attend those meetings every single month, either in person or virtual. So again, it all starts and stops with your license. And it's so great that you come to events like this, but take a little time, consider taking time to log on to a Real Estate Commission meeting. Brokers, make that your training for the month. Have your agents attend the meeting virtually. They can do so from the comfort of their home, from your offices. There is a link on the Real Estate Commission page where they can do that. Wednesday, it's a 2-day meeting, Tuesday and Wednesday is the day where they do the disciplinary cases. And there is no better education than knowing what is causing people to lose their license, right? Learn from the mistakes of others. And so we attend these meetings and we are able to develop education programs based on what is causing people to be disciplined or lose their licenses. I can tell you another big part of their meeting is discussion regarding rules. So the legislature makes statute, but the Real Estate Commission, they make the rules. And one rule in particular that they have spent a lot of time over the last couple of years talking about is advertising. So I took a picture, a screen print here of the rules report of the Real Estate Commission from February 2022. If you take a look at the dates associated with 61J2 10.025, that is the general advertising rule, you can see that the commission started discussing this rule back in the summer of 2021, and they discussed it almost every single month through February 2022. And they seriously considered changing the advertising rule to make it more stringent, particularly in the area of social media and internet advertising. Now, if they do that, I want you to stop and think for a minute what your advertising budget is. Every business card, every piece of letterhead, every web page, every Facebook ad, everything you do to promote yourselves, your brokerage, yourselves as individual brokers and sales associates would likely have to change. And why are they talking about that? Because this rule has not changed in decades, but we still struggle as an industry to comply with the advertising rule. So I have promised the commission, Florida Realtors has committed to making sure that we educate our members on the importance of compliance with the advertising rule. I need every person in here to make sure that you take a look at this rule and you start to ensure that your advertisements comply, okay? Because if we do not, then we're going to probably find ourselves with a brand new advertising rule that will require us to reprint all of our advertising. And that, folks, can get very expensive very soon. So please pay attention to your advertising. The last thing I'm going to say to you regarding important issues with Florida Real Estate Commission, and we talked about this a couple of legal updates ago. Change your email addresses timely. A couple of years ago, the Real Estate Commission changed this particular rule, Rule 10.038, to require that not only should licensees keep a current mailing address on file with the commission, but they must also update their email address. So I want all of you today to make sure that you go to myfloridalicense.com, you log into your online account, and you verify the email address that you have provided to the Florida Real Estate Commission. If the email address is not correct, you run the risk of missing vital information and notices from the commission. And I cannot tell you how many times people have found themselves in a disciplinary case because they say, I didn't get that, or I didn't know that I needed to respond, or I didn't know that I needed to provide something to the commission. So I need you to make sure that your email addresses and your mailing addresses are current with the commission. Now, that is all I have for you today. It has been an absolute pleasure. We love being able to provide the Florida Realtors legal hotline to you. We love being able to provide legal products, services, and tools to you. We thank you for joining us today, and we look forward to seeing you all again real soon. Have a fantastic rest of the convention.